some problem. So again, Mr. Tariq is an alumnus of Faculty of Law, Jamia Millia Islamia. That's my alma mater too, New Delhi. And he is currently holding the position of Principal Associate Dispute Resolution of Advani and Company, New Delhi. And to begin with, he is an advocate, he's a columnist, he's a published writer. In fact, people must know that he has written a book just published by the title On the Rise. And he's a regular visiting faculty, I must say, in these terms, to many institutions. In fact, he's also given training programs to some experts in the field, to I think police personnel, to in different bar associations in Delhi. And he in fact holds expertise in arbitration and other alternate dispute resolutions. So with these words, with this brief introduction, I quickly pass on the mic to Mr. Tariq Ahmed Khan, so that without any further ado, we can immediately begin our session on international and domestic commercial arbitration. Tariq, over to you.
Thank you so much, Ayush. It's in fact a great pleasure to be a part of this amazing series on commercial law. And I'm privileged that KLE thought of me to be the resource person for the inaugural session. Unfortunately, due to the pandemic, we are not physically present with each other, and there is no mic that Ayush you can hand over to me. But definitely, it's actually a great platform where people are connecting on these virtual platforms. And thankfully, these platforms have bridged the gap, and there's no hurdle anymore in accessing education or learning of any kind. So today's topic, Ayush told me that it is going to be about conduct of domestic and arbitration proceedings, as well as in international arbitrations, that how proceedings are conducted. I know due to the pandemic, you have seen and you have witnessed a lot of webinars. And in most of the webinars, I think you may have seen about arbitration. But today's webinar, we'll try to keep it slightly different. I have been told that most of the viewers, most of the participants would want to know the basics of arbitration and how the arbitration proceedings are conducted. Incidentally, you will not come across any book which would tell you how and what are the different stages of an arbitration. And you may perhaps not come across the differences which are there in conducting a domestic and an international arbitration. Though in principle, both the proceedings are same, because at the end of the day, both of them are arbitration proceedings. However, in substance, and if you see at the way they are conducted, so international arbitrations are much more organized, mostly because mostly the institutions are involved and there's more money involved. And therefore, there are some distinctions, the key distinctions in the conduct of international and domestic arbitrations. Now, I will straight away take you, because we have, due to paucity of time, it may not be possible for me to keep you posted about each and every development and draw an analysis between the both types of arbitration. What I'm going to do is, I'm going to tell you the procedure, and then I'll tell you what are the procedures which are there in international arbitration only. So as you know, the arbitration, okay, I will start from what is arbitration. Arbitration is basically a mechanism to resolve disputes outside the courts. And the reason why people prefer arbitration, and today it has become extremely popular amongst the stakeholders, as well as amongst the law students and all the stakeholders, I must add, is because it is cost effective. It is very fast, and especially after the recent amendments of 2015 to the Arbitration Act 1996, the time period of finishing an arbitration, which means to pronounce an arbitral award, was reduced to 1 year, which was extended by 6 months. However, recently after the 2019 amendment to the Arbitration Act, the same has now been changed to 6 months for completion of pleadings and then 12 months for pronouncing the awards. The said period is then extended by consent of parties if the arbitrator does not pronounce the award. then another 6 months can be mutually extended. So still, if you see, in comparison to the protracted litigation, arbitration is a preferred choice because nobody wants their money to be involved in dispute for a very long time. People want to take out their money so that they can invest it in other projects and do business. So if you look at the commercial aspect, any entity which is investing in our country or perhaps is into business, any MNC for that matter, they would want that their dispute, because disputes are inevitable, they are bound to arise. You and I cannot foresee that tomorrow what will happen. So as lawyers, we have to ensure that tomorrow if a dispute arises, then it is incumbent upon us to ensure that the dispute is resolved in the best possible manner and by effective uh, channels. And therefore, people prefer arbitration as a dispute resolution mechanism. Now, how do you ensure that tomorrow if a dispute arises, then how do you make sure that it's not going to the court, it goes for arbitration? The very simple way of doing that is you simply put a clause in the agreement, which is called dispute resolution clause, also known as arbitration clause. The good thing about this clause is that in this clause you write, so it's like any other clause in a contract, because a contract may have many clauses like consideration clause, payment terms, time period clause, termination clause, indemnification clause. Similarly, there's a dispute resolution clause wherein parties will agree that tomorrow if disputes arise, then how are we going to resolve our disputes? The standard language of a dispute resolution clause, which is the arbitration clause, is that any dispute arising out of or in relation to or in connection to this agreement shall be resolved by an arbitrator to be mutually appointed by the parties. The language of arbitration shall be Delhi, and the law governing the arbitration shall be Indian Arbitration Act 1996. So that's the standard form of arbitration agreement and dispute resolution clause, which you will see. And that is something which is used in almost all common contracts. Now, suppose tomorrow if disputes arise between parties, then what is the first step that you undertake? The first step that you undertake is that you will obviously try to invoke the arbitration clause. So suppose there's a dispute resolution clause between me and another entity and disputes arise tomorrow. So my first step for commencement of arbitral proceedings will be invoking the arbitration clause. Now, why is invoking arbitration clause essential? Invoking arbitration clause is essential because unless you don't invoke this clause of the agreement, then you cannot say that proceedings have commenced. So if you look at the language of Section 21 of the Arbitration Act, the Indian Arbitration Act 1996, it categorically states that an arbitral proceedings will said to have been commenced when one party sends a notice to the other party and the other party receives it. That is the date on which the arbitration is said to have been commenced. Therefore, the first step for conduct of arbitral proceedings also, which is the commencement step, has to be invoking the arbitration clause of the agreement. Now, there are two types of arbitration, like I pointed. One is a domestic arbitration. Now, what is a domestic arbitration? A domestic arbitration is an arbitration which is between two local entities. By local, I mean that two entities belonging to the same country. So if there is a dispute between me and a company which is based in Bombay, Gujarat, anywhere in India, any dispute between us will be considered as a domestic arbitration because it is between two entities that are subject matter of or situated in India. Similarly, international commercial arbitration in the Act has been defined under Section 2 as an arbitration which involves a foreign element. So now if you see that in any arbitration, there is one foreign party involved, then that arbitration becomes international commercial arbitration and it is not domestic arbitration anymore. Apart from this kind of classification, there is another classification, which is that, okay, I've been receiving some questions. We will be taking questions after I'm done. Then we'll be taking some 4 or 5 questions. Whatever I usual shortlist, I'll answer all your questions. Let me just first finish. So international commercial arbitration is slightly, if you see in terms of conduct, slightly different, but I will try to cover it, like, because both the things have most of the stages in common. So I will give you that common stages which are involved in both. Now, as soon as you invoke your arbitration clause, the first step is that in your notice invoking arbitration, you will write that disputes have arisen between the parties, and you will say that parties have tried their best to amicably resolve their disputes, but disputes are not being resolved. Okay. And then you will say that I am appointing Mr. Ayush as the arbitrator in the matter. Now, the other party will, of course, reply to this notice. So this is not a legal notice. This is called a notice invoking arbitration under Section 21 of the Arbitration and Conciliation Act. The other party will then reply to your notice, disputing all your allegations, saying these are wrong, nothing is payable to you, and will say we do not accept the nomination of Mr. Ayush as the arbitrator. They will deny any arbitrator you are appointing if it is a sole arbitrator. So arbitrator can either be a sole arbitrator or any odd number, 1, 3, 5. This is as per Section 10 of the Act. Because no point of having even number of arbitration, because in case of a disagreement between the two, eventually you will see that we will be back to square one. So that's why the number has to be an odd number. Now moving forward, once the parties are not in agreement as to who should be the arbitrator is the judge who will decide the dispute between the parties. The next thing that happens is that you, being the claimant, because your money is at stake and you are claiming the amount, you will have to then approach the court under Section 11. Now, Section 11 is basically the section for appointment of arbitrators. In case parties do not agree to a common name for the name of the arbitrator as to who is going to resolve their disputes, in that case, the appointment of arbitrator is done by the court. Now, there is a slight difference between domestic and international commercial arbitration here. If the arbitration is international commercial arbitration, then only the Supreme Court has the jurisdiction to appoint the arbitrator in the matter. Whereas if it is a domestic arbitration, then in that case, only the concerned High Court will have the jurisdiction to appoint the arbitrator. Now, that's the first difference which I have told you in domestic and international commercial arbitration. Moving on, once you file a Section 11 application and the court appoints an arbitrator, the arbitrator will first give a disclosure in terms of Section 12, which talks about a disclosure to be given by the arbitrator saying that I will be impartial and there are no grounds which affect my independence and impartiality, and I will be fair. And he will also disclose any past, present, or any relationship with the parties or their counsels which may affect the proceedings or the result of the dispute. So that is only to ensure that he's impartial and he's independent. And this is as per Schedule 5 and 7 of the Arbitration Act, which you can refer to if you want to know more about it. Now, once the arbitrator will give this undertaking, which is a disclosure, arbitrator will have to mention also that he will be able to devote sufficient time to the arbitration and he'll be able to finish the arbitration in 12 months. Now, once this disclosure is given, and if parties do not challenge, because in some cases parties do challenge the arbitrator, saying that he is not impartial, he is not independent. There are some cases, and for that they then challenge the grounds. Anyway, I'm not going into that aspect because that would make it too long. Now, straight away coming to the next step, which is that arbitrator will then hold a hearing. He will be conducting a hearing between the parties. He will invite both the parties to be present there. This is called in a way a preliminary hearing. And in that hearing, the arbitrator will then pass a procedural order. What is the procedural order? A procedural order is basically that order in which he will determine the course of the proceedings in future as to how they are going to go forward. So in arbitration, party autonomy supersedes everything. Parties decide how they want to resolve their dispute and how do they want to go forward with it. Now the arbitrator will ask the counsel of the claimant as to how much time will the claimant require to file its statement of claim. So once the statement of claim is filed, suppose the claimant says I will file it in 4 weeks, which is a general norm. Then he will ask the respondent, how much time will you take to file your statement of defense? Because to the claim, there has to be a defense. And once the claimant respondent says that I will file it in another 4 weeks, so there is another case. The statement of defense can be accompanied by a counterclaim also, because in some cases, the respondent wants to file a counterclaim because he says, I also have to recover money from him. So then it is a counterclaim. And in that case, the tribunal or the arbitrator will have to give time to the claimant to reply to that counterclaim and the rejoinder, of course. So this is the first stage, which is the stage of pleadings. Once the pleadings are complete, the next stage is framing of issues and admission denial. So parties will file admission and denial of their documents. Now, what is admission and denial? So suppose the claimant has filed 50 documents in total. The respondent will have to file an admission denial to each and every document, wherein the respondent will either admit or deny the contents or the document. So it can be, so suppose I am relying on a document, a letter, then the respondent can say, this letter is denied. Or if the respondent is agreeing that yes, there is a letter like that, then they will say it is admitted. And if they are saying, yes, it is admitted because I have received it, but I am disputing the contents thereof, like a legal notice or the notice invoking arbitration. So they will say receipt admitted, contents denied. That's the norm, general norm. So this is the stage of admission denial, wherein parties will admit and deny the documents of each other. Once that stage is over, the tribunal will then ask for framing of issues. The idea of having a stage of admission denial is to reduce the controversy, because suppose if out of 50 documents, 40 are admitted, then there is no dispute and these documents do not have to be proved, because admission is the best form of evidence. And if both the parties are relying on it, then tribunal can clearly rely on those documents without any hesitation while arriving at a conclusion. Now, while framing issues, the tribunal will ask the parties to give their draft issues, what is to be determined by the party, by the arbitrator, and what is the controversy, so that the tribunal can understand what are the actual issues which are arising out of the present matter and what is to be answered by me in the arbitral award. Now, these issues are framed. These are questions essentially. And now to address these issues, the next stage is called evidence stage, which is the most crucial stage in any arbitration tribunal matter. Now, in any arbitration, evidence is of utmost importance because all these documents have to be proved by some witness. So parties are asked to give the name of their witnesses, a list of witnesses is filed, and then the tribunal will fix date of cross-examination of those witnesses. If at all parties agree that there should not be a cross-examination, there should not be any oral examination, then the arbitral tribunal will decide the matter on the basis of the documents which have been filed. But in most cases, parties prefer cross-examination because they have to prove their case through the witness, and witness has to be cross-examined by the other side's lawyer, who can then arrive closer to the truth and show that, look, this witness credibility, he cannot be relied upon because he will question the credibility of that witness. So that's the idea of a cross-examination, to give an opportunity to an individual to show that his evidence is weak and poor and cannot be relied upon by the tribunal. Now, once the evidence stage is over, the next stage is of arguments, the final arguments. parties are asked by the tribunal to argue their case in which parties will then quote these relevance excerpts from the evidence and will also rely on the documents and will rely on some judgments of the court to support their case, to assist the tribunal in arriving at a conclusion. And then written submissions are also filed by the parties, pursuant to which the tribunal will then pass a final award. Now, once the tribunal passes an award, that award is in the form of a judgment. The only difference is it is confidential, because arbitral proceedings are confidential, unlike court proceedings. And that award, if one party is not satisfied with the award, then that award is challenged in the court under Section 34 of the Arbitration Act. Under 34, there are very few grounds which are available to the party which is challenging the arbitral award. Essentially, public policy is one ground. Public policy means that anything which is contrary to the Indian law or which is against the fundamental policy of the Indian law. So something which is so patently illegal that the arbitrator has awarded, only in such cases the arbitral award is set aside by the court under 34. Therefore, what I'm trying to explain to you is that under Section 34, the scope of interference is very, very narrow. It is not like any other judgment or appeal in which the court is sitting, where courts can go into the merits of the case. No, the court cannot go into the merits of the case. The court can merely look at something which is prima facie so illegal that no reasonable person would have come to that conclusion. Only in such a case, the court will interfere under Section 34. Now, few interesting judgments that you may want to read in this regard. There's one judgment which I would want you to read, which is Sangyong judgment by Justice Rohinton Nariman, which is a 2019 judgment. It is very useful. And before this, there was a judgment of Associate Builders that you may also refer to see the narrow scope of 34. The court does not have many powers. There's one thing which is to be kept in mind, that if you are challenging an arbitral award, the time period as per Section 34(3) of the Arbitration Act is 90 days from the date of the receipt of the award. Now, if you want to challenge this beyond that, there's only a 30-day more grace period which is provided, but that is also subject to the court's discretion. So which makes it 90 days as a matter of your right, and another 30 days, if at all due to some personal difficulty you could not file it, then 30 grace days are given to you, which makes it a total 120. But this 30-day grace period is not a right. The court may reject your application if court is not satisfied with each day's delay. You have to give an explanation as to what stopped you from filing the 34 within 90 days. Now, once the 34 decision comes, assuming that the court takes a decision that the award is perfect and rejects the 34 or dismisses the application filed by the losing party, then the next recourse available to an individual is filing an appeal under Section 37. Now, 37 provision of the Arbitration Act basically talks about appeals. So if you look at the language of the section, it clearly says that an appeal shall lie from the following orders and no others, which means that only those orders prescribed under Section 37 can be appealed against, and no other appeal is available except where specifically provided in 37. Now, if the 37 court says that, yes, I am upholding the judgment of the 34 court and says that there's nothing wrong with the judgment, then the only last resort available to an individual is Supreme Court, SLP. So you file SLP against that order, and that is the last resort. Pursuant to that, the winning party will then move an execution petition, which is under Section 36 of the Arbitration Act. And as per Section 36, the award of the tribunal will then be treated as a decree of the court, exactly like a decree of the court. And the party which is challenging this decree will have to then make a deposit of 50% is the general practice. But nowadays, the recent trend is that courts are directing the parties, the losing party, to deposit 100% of the award amount in the interest of justice, so that the winning party is not deprived of the fruits of the award. That's the whole rationale. Now, this is the case with arbitration, which is a domestic arbitration. So most of these things and procedures are there in the conduct of an international arbitration also. But I will briefly sum up in the next 5-7 minutes, and then we can perhaps be open to questions, because I think 30 minutes have passed and I've taken too much time explaining you the domestic arbitration, but that's one thing which you'll be doing more than international arbitration. So in international arbitrations, the practice is slightly different. So unlike the domestic arbitration, where I told you mostly arbitrations are ad hoc. So the arbitrations are of two kinds. Apart from domestic and international, there's another categorization. It is called ad hoc arbitration and institutional arbitration. So if you look at what is an ad hoc arbitration, ad hoc means that parties will make arrangements on their own without the supervision of any institution supervising it, or making it smooth. Like if I'm the claimant and Ayush is the respondent, we will ensure where is the venue, we will coordinate with the arbitrator, everything will be manually done. No such third party or institute involved in making it smooth. So this is a typical domestic arbitration. Whereas the other kind of arbitration is institutional arbitration. Now, if you look at institutional arbitrations, these are institutes, like I'll give you example of some institutions. In India, we have MCIA, Mumbai Center for International Arbitration, then DIAC, Delhi International Arbitration Center, and internationally, the most popular ones are ICC, International Chamber of Commerce, SIAC, SIAC, Singapore International Arbitration Center, and so on. So if in the arbitration clause, you specify that the arbitration will be conducted under the aegis of these institutes, so then you are agreeing and you are being subject to your arbitration will be conducted subject to the rules of these institutes. So each institute has its own rules of conduct of proceedings. So suppose an arbitration is to be conducted by ICC. I'll give you an example. So when I am entering into an agreement with a foreign entity, generally they would not want an Indian arbitrator because they are a foreign entity, and they would not want India to be the seat of arbitration. So mostly in international arbitrations, you will see that seat of arbitration is neutral, not to the home country of either parties. So the procedure is simple. If in case a dispute arises between two parties which are not from the same country, then a request is sent to the concerned institute, a request of arbitration with the registration fees. And then suppose it is a case of ICC arbitration. As per the clause, the parties had agreed and submitted to the rules of ICC. So they will send a request for arbitration. The claimant will send, of course, saying that this is my case. I want to file an arbitration against Mr. So-and-so. And as per clause so-and-so, ICC is the concerned institute. Therefore, kindly take proceedings further. ICC will then reach out to the respondent. Suppose I'm based in India, I'm a respondent, and ICC will say, look, a request of arbitration has been received against you, and this is how it is. Then the next stage will be in relation to appointment of an arbitrator. ICC has a panel of arbitrators. So ICC, what it does basically, if mostly in international arbitrations, because the stakes are high, there are 3 arbitrators. So one arbitrator appointed by each party. So one arbitrator may be appointed by, suppose the other party is from London. So they will appoint one arbitrator of their choice, and they will tell that to the institute. Then institute will ask me to nominate my arbitrator. I will appoint one arbitrator. So these are 2 nominee arbitrators. Then the neutral arbitrator, who will be the presiding arbitrator, will be decided by the institute itself. So institute will say, okay, I will decide the presiding arbitrator, who will be the chair in the way. Now this presiding arbitrator, once he is appointed by the tribunal, that's one procedure that the institute will keep following to ensure that the constitution of the arbitral tribunal is complete. Because unless these 3 people are appointed, the matter cannot proceed. In the meantime, what the institute will say, the ICC will send an email to, there are ICC councils. So these deputy councils will send an email to the claimant saying that if you have your claim ready, you please send us the claim. So once the tribunal is appointed, it completely depends from case to case basis. Then tribunal will take the first hearing and tribunal will pass a procedural order. In that procedural order, they will mention that claim is to be filed in so and so time. And thereafter, the defense will be filed by the respondent. And something very interesting, which you will see only in international arbitrations mostly, is that parties have decided that they will, they can, because sometimes the disputes are very complex. So parties want to go ahead with an expert in the matter because they feel that sometimes, for instance, if you're in an arbitration which is international in nature and millions of dollars are involved, they want an expert to be appointed who will perhaps look into the whole matter and give his expert report to assist the tribunal, because these issues can be very technical. For instance, delay analysis, quantum issues, all these things would require the determination from an expert. Okay, so that's one thing which is what you have to keep in mind. Now, in an international arbitration, the other interesting aspect is that tribunal will give an opportunity to the parties after the pleadings are complete. Pleadings will be same like I told you in domestic arbitration: statement of claim, statement of defense, reply to counterclaim. There's no rejoinder. In domestic arbitrations, you will see it is common to have a rejoinder, whereas in these arbitrations, in international arbitrations, you will not find any rejoinder. Now, moving forward, tribunal will then ask the parties to submit a request for documents. Now, the next stage is a request for documents. Of course, there's a terms of reference also which are finalized, wherein parties are asked to give their comments, the brief case that they want to present, and what are the issues that they are proposing. All that is written in the a document called terms of reference. It's like the summary of the case that both parties will give, and they will also be giving their proposed issues then and there. Now, the request for document is done in a particular format. Mostly in international arbitration, they follow a format called red fund schedule. Now, this schedule, you will give a list of documents that you want from the other side. In domestic arbitrations, you have to file a separate application, which is called discovery of documents or disclosure of documents, because there may be certain documents which are in the possession of the other side and on which you want to rely. So that's one thing. Apart from this, there's another thing which you should keep in mind is that this red fund schedule that I'm talking about, this schedule has a format in which you will give the details of the documents that you want from the other side, and then the other side will get an opportunity to give its comments on those objections on those requests, that no, I will not give this document for XYZ reason. And then the tribunal will rule on each and every document whether it is to be produced by the other side or not. So this is the red fund schedule, which is very unique to international arbitrations. Now, once this request for disclosure is over and you get all documents that you want, the tribunal will then ask you to give a list of factual witness. Okay. Now, these witness statements are to be filed. That's the terminology which they use in international arbitrations. And suppose you say that, okay, I have 3 factual witnesses, and the other side will say I have 3. And they also ask you if you have any expert witness. So both the parties can appoint their own expert to give testimony in relation to the case. So these are called independent experts, though they are appointed by parties. Now, assuming that you submit your factual witnesses, there is another opportunity given to the other side to rebut these factual witnesses. Now, this is called rebuttal witness statements. So if you have presented 3 factual witnesses, the other side will get an opportunity to counter those affidavits by the other side. Same, likewise, the other party's witness, you will have to counter with your witnesses. So these are called rebuttal witness statements. This is also something unique, which is only in international arbitrations, which I have not seen in domestic arbitrations. Now, another interesting thing is that if you have an expert and the other side also has an expert to give their testimony on a particular issue, so there will be expert reports which will be filed by both the parties. Now, tribunal will give them an opportunity to these two experts to meet and to discuss whether they want to come to an agreement on the report and to point out if there are any differences on the report. Okay, that's the other thing. Now, assuming that the experts meet and they do agree on some part of it, suppose they say, okay, we agree on 5 points, but we disagree on 5 things. So now the things which are on which they have disagreement, that is what the tribunal will have to see, that which expert to believe and to rely upon. Now there are various methods of cross-examining an expert. Now suppose I have appointed an expert to give testimony on a particular issue, then the other side will get an opportunity to question him on his expert report and to show that he is not an expert, and his credibility, to shake his credibility, basically to say that tribunal should disregard his report. That's the whole idea of a cross-examination of an expert. The other method is hot tubbing, wherein both the experts are made to sit together and the tribunal throws questions at them and they have to answer. So there are different methodologies that tribunal may adapt subject to its convenience and the way it wants to take out the truth from these experts, because tribunal may have many questions to which the experts may be able to assist the tribunal with. Now, once this stage is over, the next stage which comes is the stage of once the evidence is recorded, this is the evidentiary hearing which takes place. That is when everybody meets, the tribunal comes, mostly the arbitrator is from a neutral country. They will come, they will conduct hearings, it will get over. And after that, the tribunal will decide, direct the parties to file pre-hearing submissions. Now, these are skeletal arguments which you give to the tribunal before the main hearing, which is for the final arguments, in which you tell the skeletal of your arguments, and there is an opening statement which you then start with. You tell the facts, you present your case, and then you argue your case. Mostly equal opportunities are provided in international arbitrations as well as in domestic arbitrations to both the parties. So suppose one day is fixed for claimant's arguments and one day will be given to the respondent's argument. And sometimes it is for cross-examination, it completely depends on the number of witnesses. Now, once these pre-hearing submissions are filed and the final arguments take place, after that, there are post-hearing submissions, which is also called post-hearing briefs, wherein whatever has been argued, whatever judgments have been cited before the tribunal, all of that is then compiled in a document and filed before the tribunal by both the parties. There is one interesting thing about international arbitration. It is that there are transcribers which are used. So generally in domestic arbitration, you will see those traditional method of typing by stenographers and cross-examination, which takes a lot of time. Whereas in international arbitration, transcribers are engaged. They charge quite a lot. They're expensive, but it saves a lot of time and it is extremely convenient. How? Because anything you are saying is being typed on the screen immediately without wasting any time. So transcription services are very relevant. All these transcripts are ready and can be read comfortably by the tribunal. And at the time of the award, also tribunal has everything that happened there in writing. And it is very quick without wasting any time. So that's one essential feature which I must highlight. Now, lastly, one thing we must keep in mind that when an international award comes, it is different from a domestic award because, like I pointed to you, an international arbitration is governed by Part 2 of the Arbitration Act, and domestic arbitration is governed by Part 1. Now, if there is an international award, international arbitral award, the courts will not interfere with it, even if it is patently illegal. So the grounds for challenging a foreign award is much, much narrower, the scope, than a domestic award. So domestic award may be set aside if it is patently illegal on the face of it, whereas a foreign award will not be set aside on this ground. So the scope of interfering with a foreign award is even lesser. So that's the idea, because the government wants, that's why the legislature came up with these amendments to ensure that foreign awards are respected and parties feel comfortable in investing in India, because of the approach and the image of the Indian court was not that good, and they were not considered arbitration-friendly jurisdiction. However, in recent times, the reverse trend has been shown. The Supreme Court is not interfering with many foreign awards, which is encouraging parties to enter and invest in India. Foreign direct investment is directly dependent on it because they are concerned about how disputes are being resolved by that country and its courts. And thus, when the foreign entities and foreign entities, they see that Indian courts are encouraging arbitration, then they're happy and they feel comfortable that yes, India is a good place to invest and we are going to feel comfortable investing there. So that's the long and short of domestic and international commercial arbitration. I think exceeded my time. Now, if we have any questions, I'll be happy to answer a few of them. Ayush, are you there?
Yes. There are a bunch of questions actually with us, Tariq. First of all, I'll apologize to all the participants that we won't be able to ask all the questions because of the paucity of time. So I have shortlisted few questions using my own discretion. So I've narrowed down it to about 4 to 5 questions. I'll ask it one by one, or do you want me to ask it together and you want to answer it together?
You can ask me. You can ask me one by one, no problem, Ayush.
Yeah. Okay. So the first question which I'll ask from the participants would be that how to conduct the ADR proceedings during this pandemic. I think that's a good question, and people would actually want to get an answer to the situation, the real situation of the ADR proceedings.
I appreciate it. So that's a very interesting question. There have been interviews and webinars on this day and night. But yes, I must answer this. So virtually it has been, initially there were a lot of difficulties, especially during cross-examination, because parties were not in agreement. So suppose if I had to cross-examine the witness of the other side, so that requires a lot of reading and documentation. And sometimes the counsel was not comfortable doing it virtually. A, they did not know who's sitting with the witness and whether the witness is being tutored or not. And B, it requires a lot of assistance from your colleagues and a lot of documents are to be gone into. So if the record is voluminous, then parties would of course prefer a physical hearing rather than a virtual hearing. But nowadays, we have understood that this is here to stay. And these, a lot of people have seen virtual hearings as a development rather than a curse. And we are seeing it as an evolution of arbitration. So yes, we have adopted to these methods and technology is helping. It is making things smooth. You don't have to travel for attending a matter in Bombay. A lot of foreign arbitrators had to travel for hearings and they had arbitrations in Canada, Switzerland, India, different jurisdictions. Now they can sit at the comfort of their home and attend as many arbitration hearings as they want. So technology is definitely helping. And yes, arbitration hearings are being conducted smoothly day and night. In fact, today itself, I have finished an arbitration just now, right before this webinar. The final arguments were concluded. So honestly, due to the pandemic, yes, initially it was difficult, but now virtually it's happening. Everything is, even the courts are functioning. So yeah.
Okay, so the next question is, what are the main steps in a pre-arbitral stage in an international commercial arbitration? So the pre-arbitral stage, if you can throw some light upon.
So before the arbitration in most of these contracts, you will see that the kind of dispute resolution clauses, the way they are worded, it includes med-arb clauses essentially. What are med-arb clauses? That you will first go for mediation and try to settle your disputes amicably rather than directly jumping to arbitration. So parties always endeavor that because huge amounts are involved, we must make attempts to settle the dispute by mediation first. So they fix a timeline. They say that we'll try to get it done. 30 days parties will try to mutually resolve. So you cannot directly invoke arbitration. And if it fails, then you will perhaps invoke arbitration. Apart from that, as such, there are no pre-arbitration steps. The first step, like I said, is the notice invoking arbitration. So once the mediation fails between parties and all those efforts which parties take to resolve disputes amicably, they fail, then the only resort they have is to send a request to the concerned institute as per its rules. So you have to ensure that you are following the rules of that institution under the aegis of which the arbitration is going to be conducted. So they have steps that how you have to commence the arbitration, how you have to raise a request, what is the format. So all of that have to be complied with, and that's how it is.
So there is one more question. It is, how can we interpret section 42A of the Act in light of section 34, since section 42 allows disclosure of award only for its enforcement and not for challenging award? I hope the question is clear. Or
Yes,
should I repeat?
the question is clear. In fact, there have been a lot of debate regarding this. And in fact, the 2019 amendment, which is coming, it does talk about confidentiality. And it does emphasize that only for the limited purpose. You see the amendments, I don't know which exact provision it is. But in the 2019 amendments, there is a clear discussion, because in fact, in one of my articles, I had written the issue of confidentiality, that though people say that arbitrations are confidential, but when you take somebody to the court of law under 34, the arbitral award as well as everything is out in the public. So where is the confidentiality? It goes for a toss. But the 2019 amendment, it does talk about certain provisions regarding confidentiality and how they are planning to make changes to it. I'm not sure if it has been implemented. I don't think it has been, that part of 2019 amendments. Whereas, but to be very honest, uh, confidentiality cannot be, in my personal view, be maintained in a 34, and it is extremely necessary that the record is filed, because no court will give its decision without going through the merits of the case and without going through the record, arbitral record. Whatever was there before the tribunal has to be there before the court. So yes, I mean, even if you have to compromise on confidentiality, it is what it is.
Okay, so there, if we still have about 10 minutes before we can stop, so I think I can ask a bunch of questions. So there is one more question.
Yeah.
Do the national courts of either of the parties, I think this relates to international commercial arbitration, do the national courts of either of the parties have supervisory powers in light of granting anti-arbitration injunction over the arbitration proceedings, especially when one of the parties involved is state? So I think the question is twofold. One, it relates to the supervisory powers of the national courts, and there is a context that is anti-arbitration injunction in light of granting anti-arbitration injunction, especially one of the parties is state.
Yes. So, I mean, we have seen recently, of course, the courts of the country will have the supervisory jurisdiction if the arbitration which is being conducted, like for instance, I'll give you 3 cases in India, which you must read to enhance your knowledge on this subject. It's a very interesting and vast topic. So entire arbitration injunctions are basically issued by the domestic courts, wherein they say that arbitration cannot go on in the other jurisdiction, or if there is any seat as any other country. How they do it, basically, you read the judgment of Vikram Bakshi in the McDonald's case, then you read the judgment of Justice Manmohan. He has passed a judgment in Vodafone case, and the recent one, which is going to be pronounced any of these days, is the judgment in Lalit Modi versus Beena Modi case, wherein the cases of anti-arbitration injunction. Ordinarily, courts should refrain from issuing such injunctions because it is not arbitration friendly and it is not a pro-arbitration approach. Therefore, the courts generally and mostly what I have seen have said that we will not be issuing such injunctions because we do not want to stop or stall arbitration proceedings anywhere. But yes, in some cases, some countries I've seen that when the state is an entity and it is involved, then states do end up issuing such injunctions. But the idea is, to be honest, if you are trying to show yourself as an arbitration-friendly jurisdiction, then the courts of that domestic national, any nation for that matter, national courts must refrain from issuing such injunctions to give a positive message to the arbitration fraternity at large.
Okay, Tariq.
Yeah.
Yeah, so there is one more question. It's not related to actually commercial arbitration. It's a bit offbeat question. If you please answer this also.
Yes.
Does the ADR work in criminal justice system? And if you can throw some light on alternative conflict resolution, I mean, if you can, something.
Essentially, I'll tell you, so far as the criminal justice system is concerned, I mean, there are criminal matters. Like, I'll give you a very interesting example of fraud, which has been an issue forever, whether fraud is arbitrable or not. So any fraud which is which is such serious allegations of fraud are involved, which are being investigated by, SFIO and EOW. So it is of such criminal nature, then of course it is not arbitrable. I'm giving the perspective of arbitration in criminal matters. But yes, there are disputes which parties are, if you talk about mediation and all, in a lot of matters, criminal matters, I see day and night that parties are entering into some mediation, some settlement agreements, and courts are questioning the FIRs. Though per se there are certain offenses which are not subject, which cannot be quashed. The FIRs cannot be quashed if even if the parties have agreed, because it is the offense against state. But so far as arbitration is concerned, criminality is involved and some serious allegations are there, then yes, it will not be arbitrable. But the recent judgment, the last 2 weeks, we have seen two good judgments of Supreme Court. You may want to read the issue of, there's a HSBC judgment recently by Justice Nariman. Then there is Deccan something, I'm forgetting the name. That is one judgment. Avitel is the judgment which SSBC, Avitel. And the main judgments on these is Ayyar Swamy. Then you may read Amit Lalchand judgment versus Yushrab Enterprises. Then you can read another judgment of Rashid Raza versus Sadaf Akhtar. So these are the landmark judgments on fraud, which deals with the serious allegation of fraud, which involves criminality, so far as arbitration is concerned. Apart from that, like I pointed, mediation and all are successful in such matters. So yes, I mean, that's one thing which is the focus of the individuals to avoid. But nowadays, what the courts are trying to do, courts are trying to ensure that such excuses are not taken, because a lot of parties, to wriggle out of arbitration, they use such objections that, oh, this involves serious allegation of fraud, so it is not arbitrable. But courts have said, no, no, no. The two tests have been laid down in the recent judgment of Avitel, wherein the courts have clarified what kind of fraud will qualify to be serious allegation of fraud and what would not be arbitrable. The courts have said that if the fraud has been during the enforcement of the project or the contract, then that would not vitiate the arbitral clause. It would only make you entitled to the damages, but the arbitration clause will remain and the dispute will be arbitrable.
Okay, I think that would be it. There is one more question, although it's not related to arbitration per se. Actually, there's a person who asked that whether they can be trained for arbitration, and you can recommend something.
So if you want to be trained for arbitration, honestly, there are going to be institutes now after the 2019 amendments. They have an arbitration council for India, and there'll be bodies which will be accrediting arbitrators as well as arbitral institutions. There are some foreign entities which are doing courses on arbitration, like you have certified mediators. You can't be certified arbitrator, but yes, if you are a law student, I don't know what you are doing, then you can do diploma in some decent course. There are good international organizations which are doing such diploma courses for arbitration, like Cologne Academy, for instance, is one. Then, there are in Geneva, there is something in Sweden, there's something in Singapore. In India, if you want to do in Delhi, you have ILI, India Law Institute, which offers a decent course for such a diploma. So if you are doing something like that, you may learn the basics of arbitration, of course. But in my view, practice is something which is most important. Once you are actually practicing with somebody who's either doing arbitrations on a daily basis or who's practicing arbitration, that can be a great experience. Apart from that, I feel that being trained at arbitration it only comes with experience, to be honest. But yes, there are some courses for being an administrative secretary that you can do, and for other things you can learn arbitration like that. 6 weeks course, 2 months course. There are short courses like that.
I think we can, with this, we can end today's session. I thank you everyone for participating in the very first day of our national webinar series on commercial laws. And I thank you, Advocate Tariq Ahmed Khan, to give his time. I know he is very busy, and I know it was already difficult for him to make some time for us, but I'm glad that he did. And so crisply and so precisely and to the point, he gave us the very basic insights and the fundamental understanding of domestic and international commercial arbitration, the proceedings, to be particular. With these words, and again, I thank my principal of Cayley Society's Law College, Bangalore, Dr. J.M. Mallikarjunaya, and all the conference committee members and the students of this institution and whoever has contributed to make this webinar a successful one. So thank you everyone, and I request to fill the feedback form, which the link of which is already shared, before 7 p.m. and tune in at 4 p.m. tomorrow, because the second one is scheduled tomorrow at 4 p.m. And thank you so much. Have a good day. Thanks a
Thank you,
lot.
everyone. Thank you for this opportunity. Thanks, everyone. It's really nice.
Tariq.
Yep.
Are you there?
Yes, I'm here.
Okay. Please be there for a minute, right?
Yeah.
Okay. Just be there, right? I'll get back to you. I mean, the participants can go. I just had a little chat with you. Okay. Anyway, Tariq. Anyway, I thank you again, yeah. Thank you so much for being here.
It was
And
my pleasure.
actually, I was trying to, put you through with one of our faculty members and one of the faculty members from outside. He wanted to talk to you. So I was going to contact with them, but I think they're not right now in the Zoom room. It's okay. I mean, if possible, I'll ask him to maybe talk to you some other time.
No problem. You can give him my email or my number. No problem. That's fine.
Sure.
Tell him to give me your
Yeah.
reference. It's really nice. I hope you enjoyed, Ayush.
Yes, definitely. Chalo,
Perfect.
thank you so much.
Thanks a lot. Thank you. Stay in touch.
Yeah.
Bye-bye.
Okay.